In actual fact, it's the abusive personality saying, I get it that you've got an order and this is me stepping over that line. That is me showing you that the law doesn't count in my case. And that obviously can be really, really intimidating. Hello and welcome to this episode for the Survivor Diaries. This episode is on the non-molestation order and, as well as the order itself, also the procedure to obtain a non-molestation order, something that does come up quite frequently in the whole general picture of this video channel, which is how domestic abuse continues through the child arrangements. A couple of disclaimers just to start with. So I am a family lawyer in England and Wales, so if you're outside of this jurisdiction, then the law referred to will not apply to you. The second thing that I have to always state at the beginning of the videos is that the advice, any advice given is only general advice, and you should always seek advice from a solicitor or a legal advisor about your own unique situation. The key word being unique. All legal situations are unique, of course, because of the people involved. There are certain patterns, domestic abuse continuing through the child arrangements being one of these, and something that does come up quite frequently is the requirement for something called a non-molestation order. So this video is very briefly going to explain what the non-molestation order is, and then what would happen during the procedure for the non-molestation order. A bit like a video that we've done before, which is about the child arrangements, and then we've done a video on the child arrangements procedure and the child arrangements procedure when there has been domestic abuse alleged, or what should happen in those cases. So the non-molestation order, nothing at all to do with child arrangements, totally separate type of application. This is a Family Law Act application, so the Family Law Act of 1996 is where the court gets its powers to make this kind of order. It is a very protective order. The other thing about this order is that it's very specific, so it can be, for example, the classic example in child arrangements is where contact has been stopped and the abusive co-parent may be continuing to harass the non-abusive co-parent through text messages, demanding to see the children, making it ostensibly appear as though it's about the children, but in actual fact continuing the abuse and harassment of the other parent, which is something that may be ongoing. So that's a classic example. Very specific thing. So texting the other parent with concerns about the children may not in itself constitute something that you'd expect somebody to be arrested for. However, this is just coming on to the kind of order that the non-molestation order is. It's very specific, so it can be as specific as saying that the respondent is forbidden from contacting the applicant for the non-molestation order by any means, save for the purpose of arranging contact. So that would mean that following the order through, if the order was in those terms that you may not communicate with the other person unless it's about contact, and say they sent a birthday card or something similar, or just a note about any other matter at all, that may not, in the eyes of the criminal law, seem like it's a problem. Okay, so there's no law against sending somebody a letter or sending somebody a birthday card, for example. However, because of the specific terms of the non-molestation order, that could amount to a criminal offence, and a criminal offence for which the person could be prosecuted. So it's a very powerful and very specific order. And we're going to come on to what the procedure is after we talk a little bit more about what the order does and where it comes from. So the order, as I've mentioned, is part of the Family Law Act 1996. It's section 42 of the Family Law Act that governs or allows the court to make this kind of order, and it's basically an order to stop a person from causing any kind of harassment or molestation of another. And once that's demonstrated to the court, the non-molestation order is set out in the terms needed to prevent that molestation. And the breach of those terms is an automatic criminal offence. One of the things I'm going to be able to show you throughout this video is how the law is constantly updating itself. So the Family Law Act 1996, that's pretty old now. So we've got amendments to the Family Law Act. So in 2004, the Domestic Violence, Crime and Victims Act 2004 made amendments to the Family Law Act and meant that the breach of the non-molestation order terms is an automatic criminal offence. So a person can be receiving criminal sanction for the sending of a birthday card. And why is this important? This is important because the abusive person will overstep boundaries. Look, give them a boundary and they'll overstep it. So to somebody who has experienced ongoing intimidation and abuse, what may seem as a fairly innocuous thing to other people may have huge significance to a victim of domestic abuse. And the sending of that card may in fact, although it's ostensibly a birthday card and a greeting and an olive branch, in actual fact it's the abusive personality saying, I get it that you've got an order and this is me stepping over that line. That is me showing you that the law doesn't count in my case. And that obviously can be really, really intimidating. So this is just going back to the non-molestation order, bigging up the non-molestation order and what it can do in terms of those powers, the powers that make it automatically a criminal offence for breach. To obtain a non-molestation order, you have to be what is called an associated person or cohabitants or a relevant child. And the definition of what associated persons is set out in the Family Law Act at section 62. Section 62, subsection 3, it has a very extended list of the types of people that would be considered associated persons for the purpose of making this application. So people that have been in a relationship, people now that have cohabited, they are automatically maybe now in that category of people that could require this kind of protection. This is, again, an amending area, something that's changed over time. The definition of what constitutes a relationship has widened. So, for example, it's widened to include people who don't live together but have had a relationship of a significant duration, for example. And these are all ways that the law is playing catch-up with what is needed in society to eradicate the problem of domestic abuse. So the associated persons, the list, quite an expansive list, parents of the same child, that's the one that's relevant to the co-parenting difficulties that we have in the child arrangements proceedings, something that the Survivor Diaries video is focusing on. Associated persons, therefore, can make an application against the other, and it can be in terms as direct as must not use violence, must not come within 50 metres of a property or a school or a place of work, for example. The terms, as I keep referring to, can be very, very specific. So the application itself is made on application form FL 401, and we're going to put a link to that below, but FL for the Family Law Act and then 401. And this is an application that's free to make. Again, like the child arrangements proceedings, the actual application form itself is something we'll cover in a separate issue. So application form FL401 is an application for a non-molestation order and something called an occupation order. Again, occupation order, something else that the Family Law Act can do from sections 33 through to section 41. It governs the orders that a court can make when two people are both legally entitled to occupy a property. As I said, that's not something we're going to concentrate on in this video, but it is something that can be applied for on the same application form. We're going to concentrate on the non-molestation order because I want the videos to be quite short and to the point, so the occupation order is going to get a video, an episode of its own. So the application, as you are completing the form, you'll be asked to make a brief statement outlining the difficulties. The general advice given at this stage, especially if you're overwhelmed with examples, is to give the first incidence of the problematic behaviour, the worst incident of problematic behaviour, and then the last, most recent incident of problematic behaviour. So this could be attending at your property, writing letters to you that are not about the contact arrangements for the children, whatever it is, the terms of the order that you're seeking to remove that constant harassment and hassle that you're receiving from the other party. So the application is made on FL 401. Some other applications or some other orders that can be made from the Family Law Act as well, not on the same form, but this includes, because I'm talking about the general picture, so forced marriage protection orders are also a part of the Family Law Act 1996 Act. The forced marriage protection orders have been a whole part was inserted into the Family Law Act, which is Part 4, capital A, which is all about forced marriage protection orders and the making of them in particular, which has come about from the Forced Marriage Civil Protection Act of 2007. And this one has inserted this whole section, this whole part into the Family Law Act about forced marriage. And the forms to do those, FL, Family Law again, 401 is if it's an application for yourself, and FL 430 if it's an application for somebody else. Still on domestic abuse and the religious or honour issues that may come up, again we're relating to the domestic abuse, the patriarchal society thinking that can come about from that particular society or religion or culture. So female genital mutilation protection orders, these are not part of the Family Law Act. These are a criminal offence in their own right because of the Female Genital Mutilation Act of 2003. And again, it's another example of the law playing catch-up. So the Serious Crimes Act of 2015 introduced the concept of female genital mutilation protection orders at Section 5, capital A of the Female Genital Mutilation Act of 2003. And those forms, totally different start code. So instead of FL, it's FGM 001 if it's about yourself and 006 if it's about somebody else. That's just a side issue. Other protective orders, some arising as a result of the Family Law Act and some arising because they're a criminal offence in their own right. We're focusing in this episode on the non-molestation order. So you've decided that you need a non-molestation order. You need to prevent this person from approaching you. You need to prevent this person from approaching the school, threatening violence, communicating in a way that's upsetting you, causing you distress. And if you are in that situation, can I just say at the outset, please also, if you haven't done already, seek support from Women's Aid, local domestic abuse support services, your GP if necessary, and gather around you people for emotional support, medical support, anything else that you need at the same time. So the application, we're making this on form FL401. You set out a statement which includes the first, worst and last examples of the problematic behaviour, and then you can either let the other party, the respondent, know that you're going to make this application, or what is actually more common is that you can do something called an ex parte order. Ex parte means without a party to the court proceedings being present. So it does carry with it, it's a bit one-sided at this stage, so you're not going to get anything of any significant duration here. However, the usual reason for making an ex parte order is because, or applying for an ex parte order, is because you think that the respondent to the application may evade the service of the application. They may try and ignore it. And the service, to know that they've received the order, is a very important step in the non-molestation order proceedings that we're going to come back to in a little while. If you think that the person may just avoid being served with the papers and therefore avoiding service, you can make an application to the court on this ex parte basis. And once you've completed application FL401 and your statement, you should then contact your local court. And I'm going to put a link to a website below, I think it's called CourtServe, and that would have the different courts in your area. You pop your postcode in and it tells you which court you need to make your application to. In this case, because you're going on an ex parte basis, you then phone the court itself on a morning. You speak to the legal advisors, they're not the legal advisors, the court staff there, to ask when and if they have a district judge available, because you need a district judge to hear these family proceedings for a non-molestation order, especially if it's ex parte. So the court staff will tell you yay or nay, they've got a district judge available. It may be a same day thing, very, very quickly, you're before a district judge, and the district judge will look at your application, look at any evidence that you've submitted in support of your application, for example, a call register showing many, many missed calls, or a sequence of texts becoming increasingly abusive, the kind of things that you need the court to immediately see and say, yes, this is a problem. The court will then make something called an ex parte non-molestation order. And the ex parte, again, means that they've only heard one party to the proceedings. In the making of the ex parte non-molestation order, the judge will also list the matter of something called a return hearing quite quickly, because so far the court's only heard one version of events. So this is a temporary order to prevent the respondent from doing the things set out, usually, until the judge has had the time or had the opportunity to hear both parties at this return hearing. So the return hearing can be quite quickly after this first hearing, ex parte hearing, maybe a matter of days. The return hearing is where you would expect the other party to also attend, and they're going to say what they think about the making of the non-molestation order. A very important step after the ex parte hearing is that the documents must be served on the respondent. So service means involving either the court bailiff may serve the documents, and you can ask the court staff about that, or you may have to employ a process server. You can look online for a process server that's local to you. A good national group that I use and recommend, so KJH Group, we'll put a link to their website below. They're very professional, very quick, they work on weekends, and they can serve this ex parte non-molestation order on the other person for, I think, a reasonable price. The service is very important because that's the point at which the order becomes effective, when the other person knows about this order that's been made. And that's very important because if they had been still writing lots of letters before they received the order, they wouldn't have been aware of the fact that it was a criminal offence. And that means that they couldn't have been liable for that criminal offence. As soon as they've received the order, which clearly sets out that it's an arrestable criminal offence to breach any of the terms, then you can assume that they don't know about it, and therefore they can't be held liable. Once they're served, they can be held liable because then they know what they're doing when they send that birthday card, when they write again, not about contact, but having a go at the other parent, for example. So the court may serve them. You may need to use a process server. It's very important that you must not serve the respondent to a non-molestation order yourself, and it's also very important that the order is also served on the police. The police then have a record of the fact that there is that non-molestation order, and they may receive a call, for example, saying that this term has been breached and it is an automatic criminal offence, so they need to respond to it as such. Return hearing then. Both parties attend the return hearing. These are often listed for only 15 or 30 minutes because the court just wants to hear what both parties are saying. Does the applicant still want the non-molestation order? Would the applicant be willing to accept something called an undertaking, which is a promise to the court that that behaviour won't happen? I'll come on to that in a second. What does the respondent say about the making of a non-molestation order? Do they agree to it? Do they say, well, I'm not going to do any of those things anyway, so fine, I agree? Do they contest it and say that it's wrong, that the non-molestation order should be made? At the return hearing, the court's looking to see if they can establish a way forward that's not contested, so to a certain extent based on both parties agreeing. They may make an order, therefore, by consent that the non-molestation order is going to continue for a further 6-12 months. However, it's on the basis of no admissions or on the basis of no findings. So in actual fact, nothing has been said about the allegations. No findings have been made about the allegations. It's on the basis of no admissions. It may be that instead of the non-molestation order, as I mentioned previously, the applicant may be persuaded to accept an undertaking, which is a solemn promise to the court, and breach of an undertaking is contempt of court, for which you can apply for them to be then returned to court and found in contempt of court if necessary. This does not have the same immediate answer of a non-molestation order being a criminal offence and the immediate response of the police. So that's something to think about there. If there is no agreement, if the applicant is saying that a non-molestation order is required and the respondent is saying no non-molestation order is required, or actually I need a non-molestation order against them, so cross allegations even may be happening and a cross non-molestation order could be made. Either way, it's not agreed, the court is not able to get an established agreement from this hearing, and therefore the court then needs to list the matter to be tried, to be heard at a final hearing, a contested final hearing. To be able to do that and to be able to make those findings, the court will need to see evidence from both parties, and so the court will direct the filing of statements. And we've talked in a previous episode about witness statements. This is an example of where you would be gathering your evidence. You would be setting out the evidence for the making of the non-molestation order, and it's the evidence that you will rely on at the hearing. So if you have witnesses to the behaviour, you would be asking them to set out a witness statement so that it could be attached to your statement or exhibited with your statement to the court. And at this point, the court will then be able to say, okay, I can see that it's, we're going to need witnesses, we're going to need this time, and they'll be able to say how long the hearing is going to take to determine the issues, to make findings as to whether or not there should be a non-molestation order, and they may list it for half a day, or longer, depending on how many things they're being asked to make findings about. So the parties will go away making their witness statements. The parties will then return to the court for the contested final hearing. Both of them will be examined on their evidence, which is where they are, if they've exhibited, say, text messages, they'll be asked about how they came about, so that the court can make findings about whether or not there is actual molestation or harassment or something that needs a court order to stop a certain behaviour or to stop a person from continuing a certain behaviour. So you can see how these can be really useful orders. The court from this will make findings, and if necessary they'll make the non-molestation order. They would make it for a certain duration, that can be 6 months, 12 months, 2 years, depending on the submissions that have been made, depending on the circumstances of the individual case. Very important again after the making of the final order is that, you see, this will supersede the previous order, which probably only lasted until a further order at final hearing. So this order now, with its ongoing duration, while it will be valid, means that the new order also needs to be served on the respondent and on the police. Never mind if the respondent was there at the proceedings, and a copy has to be served on that person and on the police again, so that they have an up-to-date copy, usually with a different date. The non-molestation proceedings part of the Family Law Act applications, so your case number would be, for example, if it was Oxford, it would be OX19, and then it would be an F, Family Law Act, York, YO19F again. So this is just to assist you. If you've received some proceedings, you're not sure what they are, look at the case number, look at the previous episode that we have done about different types of Family Law Act applications, and you'll see there as well that the F usually refers to the Family Law Act applications, and in this case, the non-molestation order, which I hope I've set out, can be extremely useful if you're in a situation where you have ongoing difficulties, or where you have a situation where you are considering leaving a difficult relationship, or you need to stop some form of harassment or abusive behaviour. I hope that has been helpful, and I hope that has assisted you in understanding what would be happening at the court as you go through the usually 3 sets of proceedings. And I hope that assists you to make the application, free to make if I haven't mentioned that already before. Speak with the court staff, they can be very helpful, they can provide special measures which will help you be able to give evidence if you're appearing at the same time as your partner. They can put screens up, they can put you in separate waiting rooms, etc. Speak to the court staff, you'll find that they're very helpful. Speak, as I've said before, to domestic abuse support. Obtain free legal advice if you can. A lot of solicitors will offer a free half hour. You can get legal advice from the Citizens Advice Bureau, from Rights of Women. And I hope that that's been useful, and set out the different procedure, what exactly the non-molestation order is, and the procedure going through the court. Okay, I hope that's been useful. Thank you again for watching the Survivor Diaries, and I'll see you in the next episode and or vlog. Thank you again, and bye.